Honorable Supreme Court. Now, what triggered to have this subject today? Let me first of all say that on 1st August, there was a judgment from Honorable Supreme Court by the name of Pro Nits and others versus the Board of Directors of Canara Bank. And this judgment was delivered by Honorable Supreme Court on 1st August 2024. Again, on 23rd of August 2024, Insolvency and Bankruptcy Board of India circulated a discussion paper. Discussion paper is circulated whenever there is a proposal to change in the regulations. So now the IBBI is changing a regulation, which is the regulation of information memorandum, and that is also relating to MSME. So these two events triggered us to bring this subject to you. The importance of MSME framework, which was released by RBI in 2015. First, it was released by Ministry of MSME. Then it was fortified by RBI. And now it is completely fortified by Honorable Supreme Court. So this is the trigger that we are bringing this subject to you. The importance of MSME, and in case of any kind of financial stress to MSME, that is something which is now coming to a kind of landmark stage, that how the banks will have to do the resolution of MSME enterprises. Now, first of all, let us discuss what was the issue involved in Honorable Supreme Court judgment, 1st August 2024, because it's just 1 month old judgment. Name again, for the sake of understanding anyone who may have joined late: Pro Nits and others versus Board of Directors of the Canara Bank. In fact, many other applicants were there, but the name of the citation is this. Now, in this case, the Supreme Court has typically revised or revived the Supreme Court has given life to the revival and rehabilitation framework as released by RBI, first by MSME Ministry and then by RBI, how to classify NPA in the case of MSME. What is the process that the banks will have to follow for classifying an MSME into an NPA account? In fact, the court ruled that the instructions and framework issued under the MSED Act and reinforced by RBI directions are mandatory. It is not advisory. It is not directory. It is mandatory and must be adhered by the banks prior to any NPA classification. Now, the court, in fact, set aside. The background is that there was a judgment of Bombay High Court, and that judgment of Bombay High Court was set aside by Honorable Supreme Court, where it was the court, in fact, the Bombay High Court, in fact, said that the banks are not required to follow this framework unless specifically requested by MSME, emphasizing that the protective measures are crucial for supporting MSME before taking severe action against under the SARFAESI law. And that is also valid for insolvency law. Now, the judgment of Bombay High Court, that judgment, in fact, was delivered on 11th January 2024. Now, even I have to say something like, if a judgment from Bombay High Court is dated 11th January 2024, there are about 5-6 applicants and there are 10 respondents, and that judgment had gone to Supreme Court. Multiple hearings must have taken place, and on 1st August, this judgment is released. Now, in case we see February, March, April, May, June, July, so 6 months. Within 6 months, everyone has filed the application. because the application is supposed to be filed within 60 days. I'm not sure when the application was filed. And then the order must have been reserved for some time. So that actually shows that the Supreme Court has actually heard this case, and also all parties were heard, and the total decision was taken in approximately 3 to 4 months. So this is what is the efficiency of Supreme Court. However, in some cases it is getting delayed, but in this particular case, the Supreme Court thought that this is very urgent issue, MSME related. So therefore, the Supreme Court, in fact, did it urgently. In fact, in the last webinar also, I said that this judgment, that particular judgment was given by Honorable NCLAT in 2 months' time. So now in this case, the Supreme Court has given this judgment in about 3-4 months' time. So this judgment of Bombay High Court, which was in fact challenged before Honorable Supreme Court, was named as Naveen Chandra Steel Private Limited. Naveen Chandra Steel Private Limited versus Union of India. And in this case, this judgment was dated 11th January 2024, and there were many respondents, there are many applicants. All the applicants were MSME, like A. Naveen Chandra Steel Private Limited, Shri Shantinath Steels, ProKnits, CJEX Biochem Private Limited, CJEX Biochem, Foreman Textile International, Apex Consumer Appliances Private Limited, and others. These are mentioned in various writ petitions. And the respondents were, in fact, Union Bank of India, MSME Ministry, Reserve Bank of India, State of Maharashtra, and then Bank of Baroda, Canara Bank, and others. Actually, there are many, in fact. So this is a case which, in fact, had many writ petitions like this. The facts of this case is that all the petitioners are MSME, and they have challenged the actions taken by various banks and financial institutions and NBFCs while classifying their account as NPA. They actually are alleging that all the banks have taken the action under SARFAESI Act by classifying their account as NPA. They are saying that the banks have not adhered to the procedure as outlined in the MSME Revival and Rehabilitation Framework. MSME Revival and Rehabilitation Framework. This framework was originally notified under under MSMED Act, and that was in May 29, 2015, and that required the banks to identify stress in MSME accounts and classify them into special mention accounts, SMA, special mention accounts. And there were three categories of SMA accounts were made, and the petitioners argued that the banks failed to follow that process. Now the applicants in fact said that the NBFCs or the banks or the financial institutions, they are supposed to follow the MSME Revival and Rehabilitation Framework. They contended that the notification under MSMED Act required the banks to follow a specific procedure to identify the asset as MSME, and which was not done. And the banks have started taking actions under SARFAESI Act. They started taking over the properties under Section 13.2, 13.4, and then also started selling them. The respondents said, in fact, we will come to the arguments in detail little later. The respondents said that all the NBFCs and the banks, they were all the respondents. They said that the provisions of SARFAESI Act, which allows the classification of NPA and subsequent recovery actions, overrides MSMED Act. They contended that the restructuring framework under the MSMED Act is not mandatory but directory, and failure to follow it does not invalidate classification of an account as NPA. Now the respondents also asserted that the petitioner had not applied for the benefits of MSME framework. That means that they never had submitted any revival proposal. They never submitted any restructuring proposal, which we should have seen under that MSME revival and restructuring framework. So therefore, the proceedings under SARFAESI Act was conclusive, and also they were saying that the SARFAESI Act overrides the provisions of MSME Act. Now, the issues, in fact, which was before the Bombay High Court, two issues: whether MSME revival and rehabilitation framework under MSMED Act, which is also kind of fortified by RBI later, is mandatory or directory for the banks before classifying MSME accounts as NPA. Now, the second issue is that whether the SARFAESI Act overrides the provisions of MSMED Act concerning the classification of NPA, though all the provisions of MSMED Act, Section 9 of MSMED Act, Section 13 of SARFAESI Act, these are all discussed, and at length the discussions happened. And finally, the High Court, Bombay High Court held that MSME framework under MSMED Act is directory and not mandatory. As such, the failure of the banks to follow this framework does not invalidate their action under the SARFAESI Act. The court dismissed the petitions and allowed the bank to continue the recovery actions. Now, many of these parties and some other also, they filed an appeal before Honorable Supreme Court, and the title of the appeal is Pro-NITS, Messrs. Pro-NITS and others versus the Board of Directors of Canara Bank. In fact, the applicants are many. The applicants are Pro-NITS, Zuhair, Muhammad Ali Merchant, Nilesh Shah, Sadhana Bharat Roy, A. Naveen Chandra Steel Private Limited, Shri Shantinath Steel, and then the respondents were also many. It is the Board of Directors of Canara Bank, IDFC Bank, Bank of Baroda, the Kotak Mahindra Bank, Union of India. Now, again, the facts and everything we have already mentioned. Now, one is there are four issues, in fact. Now, the Supreme Court, in fact, decided on whether mandatory nature of MSME framework. So, the analysis of the Supreme Court was, like after examining, they found that the statutory framework under MSMED Act and the Banking Regulation Act, it noted that Section 9 of MSMED Act empowered the central government to issue such notifications for promoting and developing MSME. The court emphasized that these instructions, once issued, carry statutory force and are binding on all the relevant parties, particularly banks and financial institutions. And therefore, the final ruling of Supreme Court was that these instructions are not just advisory, but mandatory. And they are issued under statutory powers. Therefore, the banks are required to follow them before classifying MSME accounts as NPA, non-performing assets. So this was issue number one, which was decided against the banks. It was decided in favor of the applicants, in favor of MSME enterprises. Now, the other issue was the interaction between MSMED Act and SARFAESI Act, like which overrides the other. That was the other issue which was discussed. And in this case, the analysis of the Supreme Court was, while acknowledging the SARFAESI Act does provide a robust framework for banks to enforce security interest, the process of classifying a loan account as NPA under the SARFAESI Act is a precursor to invoking its provisions. So they are not saying, they're saying the SARFAESI Act is overriding. But what we are targeting is that when you classify an account as NPA, before classifying the account as NPA, you actually have to pass through the MSME revival and restructuring framework. You have to pass through that. You have to pass through that framework where SME 0, SME 1, SME 2, first you'll have to classify account in that particular seriatim. SME, SMA 0, SMA 1, SMA 2, and still in case there is no solution, there is no restructuring, then it is classified as NPA. Of course, the prudential norms, the rules for making an account, classifying an account as NPA is not changed. SARFAESI law overrides MSMED Act, that is also not overriding. But the classification of the account as NPA, that is not governed by SARFAESI Act. SARFAESI Act starts when an account becomes NPA. But how an account become NPA, that is not something which is defined in SARFAESI Act, because that is something under the prudential norms. And the MSME revival and restructuring packages, in fact, provide a process under which all the SME units will be classified as NPA. So that process was not done by the banks. Now, the ruling of the Supreme Court of India was that the MSME framework must be adhered to before a bank can classify an MSME account as NPA. Therefore, MSME framework does not conflict with the SARFAESI Act, but complements it by providing a pre-NPA stage mechanism. Pre-NPA stage mechanism. Once an account is NPA, then SARFAESI would be applicable. But before classifying an MSME into NPA, the banks are supposed to go through a process. The banks are not going through that process. However, it is mandatory for the banks to go through that process. We will discuss what is that process. Certainly, we will discuss today only. So this is the this is second this is a second question of law. One, as I said, that what is the mandatory nature of the MSME framework. Second, the interaction between the MSMED Act and the SARFAESI Act. And the third, the role of RBI's direction. It was also argued that the RBI has issued directions in this case. Now, the code, in fact, the Honorable Supreme Court of India reviewed Section 21 and Section 35 capital A of Banking Regulation Act, which empowers the RBI to issue binding directions to the bank. The court emphasized that these directions are issued in public interest and for the proper management of banking companies. Therefore, the RBI's direction regarding the MSME framework were therefore statutory and binding. And final verdict from Honorable Supreme Court reiterated that the banks are legally obliged to follow these directions from the RBI, reinforcing the mandatory nature of MSME revival and restructuring framework. Now, again, one issue was like while the Supreme Court of India is in fact giving a very, very landmark judgment, the Supreme Court of India also touched base. What are the obligations of MSME? What are the obligations of MSME? Now, in this case, the analysis of the Honorable Supreme Court was, while the banks are required to follow the MSME framework, the court noted that MSME also have an obligation to proactively engage with the process. MSME must provide verifiable documents and evidence of their status to benefit from the protections and process laid out in the framework. So the MSME also should be proactive. They should also try to make use of this framework, this revival framework. They should also provide the necessary documents. So therefore, it is not automatic. So it is not automatic means that the banks can also understand whether there is any possibility, and MSME also should understand that this is their right and they should apply for it. But in this particular case, the Honorable Supreme Court, in fact, upheld the application, allowed the application, despite the allegation that these MSMEs have never applied for taking any benefit under this framework. But the Honorable Supreme Court said, yes, they should also do something. They should also have some obligation. They should also try to give some documents to the banks so that they take this benefit of the framework. Now, all this, finally, the ultimate outcome of this judgment is the court allowed the appeal. Court also set aside the High Court order, but noted that since the proceedings under SARFAESI had also been concluded in many cases, so it did not remand the cases but allowed the appellant to pursue other legal remedies. So the entire process, what was done by the Honorable Supreme Court, the Supreme Court said that we are not saying that whatever has been done is nullified. Whatever has been done by the banks for the recovery process is not nullified, but they can take other appropriate actions based on this judgment, whether they were NPA or not. So in case, so that is, so some of the applicants may have got some benefit, and some where the SARFAESI proceedings in fact concluded, already sales and etc. were concluded, they probably will have to go through some other legal processes. Now, when we talk about the impact of this judgment, in fact, is huge. Now, the banks definitely will have to go through the process of MSME revival and restructuring framework. And now we will discuss after this the MSME revival and restructuring framework. And the other thing that I'm saying that looking probably from various observations from various courts, that some of the committee members are not giving opportunities to the promoters for participating in the resolution process under IBC. And also there are conflicts whether the RP can apply for the MSME registration or not. So therefore, on 23rd of August 2024, IBBI in fact released a discussion paper where the IBBI is proposing two amendments. One amendment is that is under section under regulation 36 of CIRP regulations, where the regulation 36 will be amended to require the disclosure of the corporate debtors MSME status in the IM. The RP now is under obligation to disclose whether the corporate debtor is MSME or not. And second amendment is that it is mandatory to disclose whether the corporate debtor is registered as an MSME under the MSME Development Act 2006. Now, the other amendment is that the RP also is allowed to generate a Udyam registration certificate if the facts of the corporate debtor says that this company is MSME. So that is also now permitted. In fact, there are some contradictions in the opinions. I believe somewhere an insolvency professional was reprimanded and saying that how can you apply for MSME registration? So now the IBBI has in fact clarified that an insolvency professional can also apply for MSME registration, which is called Udyam registration certificate can be obtained. Now, this is actually important to understand what the government is now. One, that the Supreme Court is favoring MSME. IBBI is also now saying that under the insolvency law, also the MSME would have under section 240 capital A, MSME promoters would be able to participate into the process and would be able to submit a resolution plan. That is also which is possible. But now let us understand what exactly is this MSME revival and restructuring framework. Now, this was introduced in 2015. In fact, it was introduced under the MSME Act 2006. And when this was in fact introduced, it was introduced with three objectives. One was early identification of stress. The objective was all the banks and financial institutions must identify stress in MSME units as early as possible. And the second objective was structured intervention. Like there should be a structure in the banks for handling such stress on the MSME, and the intervention into these MSME should also be structured. So the structure was also created as per this MSME notification and RBI notification. Then is the viability and rehabilitation. To revive MSME, then they're viable through the restructuring and other supportive measures. Now, when we actually saw that the early identification of stress, for early identification of stress, in fact, one process was published, one process was notified. And that process was that the banks, in fact, are mandated to monitor MSME accounts closely and classify them into three subcategories under the special mention account category. So the first category is special mention account category, and in the bank's total discussions and in their financial papers, all these accounts should classify as special mention account. And under the special mention account category, there are three subcategories: SMA0, SMA1, and SMA2. Now, the definitions of SMA 0, 1, and 2 is also given. SMA 0 is those account where there is some default have started. Maybe I have to say that where the payment of principal or interest is delayed beyond 90 days, then the account would be classified as NPA. However, before 90 days, before the account is classified as NPA, there are three stages. One stage is where the default of payment of principal or interest is less than 30 days. However, there are other signs which shows incipient stress. Those accounts will be classified as SMA 0, and it will figure in special mention accounts, SMA accounts. Then is the SMA 1, where the principal or interest payment is overdue between 31 and 60 days. Default is as old as between 31 to 60 days and also showing the other signs of incipient stress. Then it will be SMA 1. Then in case the principal or interest payment is overdue between 61 and 90 days, then it will be classified as SMA 2. Now, in this case, in this framework, the MSME, like MSME enterprise, can also self-initiate proceedings if they apprehend a potential failure in the business or an inability to meet the financial obligations. They can also initiate proceedings under the MSME revival and restructuring framework. Now, the committees, this particular framework has asked the banks to make certain committees. The banks are supposed to establish one or more committees at different locations. So what the banks have done, some banks have done this, they made these committees at zonal level, some at head office only, and some even at a regional level. So they have made these committees, which is the committees necessary to process the MSME accounts. And the composition of these committees are typically like the regional manager, zonal manager, or depending upon the size of the bank and the delegations in the bank. That is something which is presently happening. However, like over years, we have seen that the focus on this kind of process was little relaxed. Now with this Supreme Court judgment, this has to be like mandatory. Now the MSME can also make an application for corrective action plan when the account is classified as SMA 0, SMA 1, SMA 2. That time, even the enterprise, even the promoters can also make an application for corrective action plan. In short, we can say CAP. So this CAP, corrective action plan, can even be initiated by the promoters. And then inclusion of multiple banks. So then when we are actually talking about all these committees, all these committees to uh, the all these see these the promoters will submit their corrective action plan before these committees, that we have said that this committee would be made, and this committee would be like a committee, MSME committee, or any name the banks can given, but that is the committee which would actually oversee the stressed accounts falling under MSME, and the corrective action plan CAP proposal or a resolution plan can be given, which can be called as corrective action plan. In case there are multiple banks, so then the committee of the bank with maximum exposures, they can actually have a lead bank, and then they can have a corrective action plan. They can consider that corrective action plan, and the members of the from the other banks who are the financiers, they can also uh, participate. Now the corrective action plan can actually be having various options. Now, let us see what kind of options that we are talking about. One, that uh, we can even say that the promoters can submit a corrective action plan saying that they will regularize the account by securing a commitment from like the banks can actually regularize by securing a commitment from the borrower supported by identifiable cash flow. So this one rectification, that immediately the action can be started and the committee can ask for corrective action plan, propose collective action plan, and that the promoters can actually say that we would be bringing some money from outside or some kind of identifiable cash resource. Then, if viable, the corrective action plan can also include a kind of restructuring the account, which may include even obtaining personal guarantees from the promoters and also ensuring no asset alienation occurs. Then even the corrective action plan, in case this regularization or the restructuring or the rectification fails, then the committee may opt for the recovery processes using various legal avenues. Now, the MSME revival and restructuring framework also says that the committee must agree on a corrective action plan within 30 days of recognizing stress and finalize the plan within the next 30 days. So this is the total timeline which is given to the bank under the uh, MSME revival and restructuring scheme or a framework. And it is also mentioned that once a corrective action plan is in place and approved, then it becomes binding on all the stakeholders, and implementation must adhere to strict timeline prescribed by the RBI. So one that we have seen that this is a kind of RBI notification which is binding on banks. This is MSME notification, and they have the rights to issue such notifications, and that becomes statute. That becomes statute. And so, Ankit, is there any questions that we can take up now? In fact, or I can
So
continue.
two, three things. One, like of course, like macro level, does this kind of what is in your opinion, does this kind of become some kind of hindrance for MSMEs to take credit in some way? Will banks then set up policies to make MSME lending a little steep, or the procedure, the process which is available for banks or to banks for MSMEs is still something that they will just change their internal processes to make sure that all those things are like in place, and then they can still continue lending to MSMEs?
I think this particular framework is in existence since 2015, and SMA 0, SMA 1, SMA 2 processes are being done, and the corrective action plans are being received, and the banks are already taking actions on such plans in case it is viable. Now, the only thing that has triggered now is that the all this has to be taken seriously by the banks and the financial institutions. The promoters have the right to submit the corrective action plan, and that corrective action plan has to be disposed of in a time bound manner. And in a case it is possible, then it has to be restructured, or it has to be revived, or any additional facility. I mean, see, all these possible things can be given, and then the stress of the MSME needs to be corrected. But I don't think that it will actually have adverse impact on MSME lending. I also don't think that the MSME will actually have to bear more interest rate, because the process is already on place. The committees are already working. The only thing that the banks have to do is that they have to take a little more seriously. Otherwise, I don't think it will impact adversely on MSME in any manner. Rather, it will actually give some more force to promoters submitting a resolution plan under IBC in their own company, which is allowed under Section 240 capital A of IBC. And because of this judgment, Supreme Court judgment, even the members of NCLT will consider applications where the promoters have finally they are alleging that the committee of creditors have not considered their resolution plan, despite it was better than the others. So those kind of uh, that kind of importance will actually be revived for MSME. Yes, Ankit.
Then we have a question that basically the question is about, is there a duty for the bank to inform the MSME every time it is classified as SMA 0, 1 or 2?
Yes, it is a duty of the banks to inform the inform the enterprise that your account has now slipped to SMA 0 or SMA 1 or SMA 2, and you need to take very, very quick corrective actions. That is something that the banks are under obligation to do.
Understood. Second question that is actually coming coming is whether the circular that RBI has come out with also applies to NBFCs.
Yes,
Because
it applies to NBFC. It applies to everyone who can use SARFAESI law.
so the circular referred to is for bank. So I think we also have, similar applicable.
This is applicable to NBFCs. Very clear.
Then we are looking at, is there any way for us to know that a company is an MSME or registered under Udyam? So we have tried
Yes.
this. I don't think there is a public search to say whether some entity is registered as an MSME or not. However, like looking into the thought process here, it is important that we kind of have this kind of a search or this kind of an interaction, this kind of a system. But yeah, I don't think that's available. I don't think we can search by name if some entity is an MSME or not.
But
If,
we have the
if there is
definition.
anyone, yeah, if there is any of the participants who know a way to kind of search an MSME or by name, XYZ, in case we can search that entity and see in case it's an MSME or not, maybe they can share their thoughts and we can share that with everyone there.
So, but
Then
we have the definition with us. The definition is very clear.
registration. The question is whether it is registered as an MSME or not.
So the Udyam registration is very easy. It is a very, very simple
Udyam,
registration.
question is we don't have the Udyam registration certificate for an entity. So can we check if it's registered under Udyam? That's the question. That name search, entity based search. Then question from an RP, he says that I want to, let's say, register under MSME. So can I use my Aadhaar number? Because without Aadhaar number, the site does not allow me to proceed. So I think you're signing the MSME registration application as an authorized representative. And in case you're signing it as an RP, you can always give your Aadhaar number.
Right. Yes, yes. Very correct.
Retrospectivity, we have discussed, Ritesh ji, we have discussed that the judgment is clear that it is not applicable on the cases where some kind of process and some kind of completion has already happened. So
Yes, the Supreme
retrospectively,
Court
we have
has
Yeah.
Supreme Court has held this, that in this case, where the SARFAESI law actions have already concluded, it would not be applicable on those cases which has already been concluded.
Then a question from Arun Kumar ji. He says that if an MSME account is declared fraud, whether that borrower can submit resolution plan if it is declared as a fraud. So willful defaulter, I don't think that exemption for willful defaulter part is there in 29A for MSMEs.
No, see, like 240, section 240, capital A, only exempt two clauses. One is the clause C and the other is clause H. In case there is any other clause which is applicable to the applicant, to the resolution applicant, then section 29A would not be crossed.
So
Then
willful defaulter will then come into that picture.
Willful defaulter will come into that category where the 29A eligibility.
But fraud declaration is not same as willful defaulter actually.
Fraud declaration is not mentioned.
Not willful defaulter.
That is not mentioned in section 29A.
So whether MSME account is declared as fraud actually does not have any provision to kind of move that out under 29A. Willful defaulter is there.
See, like what I'm trying to say is that the willful defaulter is a final decision of the bank. Whereas when an account is declared as default, as a fraud, my understanding is that something needs some more kind of adjudication from any court so that finally the account is considered as fraud. That's what is my understanding. Simply by so the banks can start proceedings against a particular borrower saying that we apprehend a fraud. But like willful defaulter, the banks is a final authority.
Right. Then suppose the RP has 10 CRP, 10 CRPs and unlisted. So then we have practical problems that, okay, there are only one Aadhaar and 10 people to register or 10 entities to register. So I believe that
I believe all the 10 can be registered from the same Aadhaar because it is not mandate. It is not written anywhere in the Constitution of India that one citizen
there
can
is no and there is no process to cancel an MSME registration per se.
Yeah.
Then we have can an RP apply for MSME registration after admission of CD where CD fulfills the criteria? Yeah, we
Yes,
keep that's
exactly is written in the discussion paper.
Yeah, this is already taken care of.
That the RP needs to see the other relevant document, and in case the RP feels and RP finds that this company is MSME based on the latest definition, then the RP can apply for Udyam registration.
So one of the practical ways of checking if an entity is registered as an MSME has come from one of our participants, where he says that in case you enter the PAN number of the entity for registration, it normally throws back and says that it is already registered in case the PAN is already registered. So that's a unique way of understanding if an entity is registered as an MSME. So that's one of the ideas that has come from
Udyam registration portal. If you go add the PAN number, and then it will say that yes.
Try and register that entity with this PAN number, and it throws back and says that it is already there. Then you can always use that screenshot and then maybe do some deep digging and find the actual number. But yeah, that's there. Then if an MSME borrower's account is restructured upon classification of SME category and after 2 years of running the account after restructuring the borrower's account once again classified as SMA2, whether the borrower may again take the benefit of revival in restructuring. I don't think there is any bar on a restructuring proposal done again. Legally, there is no bar, but yes, practically, once account is restructured and it goes for restructuring again, the bank officers would need a very strong ground to say that yes, this needs to be restructured again.
Right. Very right.
Would you please elaborate more on the correction action plan as to what kind of actions are allowed to be considered by the banks? That's from Mr. Atul Tandon.
So we'll do that. Like once the question answer completes, I am still not done on the basic framework. I'm still continuing on the basic framework because of the anxiety of some people. I think the questions are supposed to be taken in between 2 times. So let me
Let's continue and then take more questions later.
Yeah. So no, can we continue for the other part?
Yes, let's continue.
So now this restructuring mechanism like as I said, that the restructuring mechanism can be because in case we see this mechanism in detail, this RBI circular in detail, then one thing is very clear that the mostly it is considered as the promoter should be followed up, promoter should be pursued to induct fresh funds, promoter should be again pursued to give another personal guarantees or other collateral securities in case promoter is finding it still confident about this project or the business. Also, the banks are saying that the normal restructuring, like in case of new units which are coming up, they can even defer the uh, commercial production, and they can actually consider that the pre-operative period is higher. They can also reschedule the term loans. They can also convert some of the loans into working capital term loan, and they can also kind of convert some of the funded interest term loan. So all these normal restructuring processes, that all can be applied by the MSME, and then the banks can see the viability. And in fact, the banks are also supposed to have this independent evaluation committee who would assess the viability of the restructuring plans. So whenever restructuring plan is given, whenever this cap is given, the cap, everyone has actually been understanding that we have to give corrective action plan. Whenever a cap is given, the banks are supposed to have the independent evaluation committees. So in fact, in case you see, the banks are supposed to have one committee, which is the committee, MSME committee, which actually will kind of the composition, the one, and then the other is the independent evaluation committee. Independent evaluation committee will in fact consider all these restructuring plans, which is you can call CAP. Also, since there are not many, in fact, earlier there used to be a corporate debt restructuring scheme, and the overall scenario is that the enterprise debt restructuring cell, see, earlier it was called a corporate debt restructuring cell, that was available in most of the banks, but then later on that was also withdrawn. And so presently there is only one scheme which is in vogue, which is available, which is still valid, is the Prudential Framework for Resolution of Stressed Assets. So this is the only Prudential Framework for Resolution of Stressed Assets is the only enterprise debt restructuring scheme which is presently open. Corporate debt restructuring is all closed, and the uh, however it all functions based on the viability, based on the promoter's commitment, based on the confidence of the promoter on the project or the business, and based on the other stakes which the promoters are taking. Then banks will definitely take some more exposure, or can also uh, consider it in a relaxed manner, and they will also defer sometimes the recovery processes or classification as NPA. However, the it has to be very, very clear that once the principal or interest is defaulted for 90 days, then the banks will definitely classify the account as NPA. See, but then whenever we are seeing that even if there is a cap uh, on the table of the bank, even if the restructuring proposal is already submitted, even if the bank committee, the independent evaluation committee is considering, but the asset classification and provisioning norms will continue. There is no stay on that timelines which are provided in the prudential norms. Now, the prudential norms are the basic document for classifying the account as NPA. This document is only giving us three further classifications: SMA 0, SMA 1, and SMA 2. But there is no change in the uh, classification of NPA. There is no stay on the clicking of the time in case while we are discussing this cap, while we are getting it evaluated, while we are preparing the restructuring plan, in case the accounts slip down to NPA, then it is an NPA account. although even after it is slipped into NPA, after this also restructuring can be done. Even after that, the independent evaluation committees can consider a restructuring plan or a cap. But that is something which is uh, again depends upon four things I said. One, the viability of the business or the project, promoters' commitment by bringing more capital or giving more security, and then the evaluation of the projections, and also the total confidence on the projections or the business models presented by the promoters. Even in this particular framework, some kind of uh, the sector specific benchmarks are also given. What should be the kind of inventory holding for a sector? What should be the what are the difficulties that can be resolved, sector specific difficulties? So, but promoters' involvement is in any case very important. Also, this scheme says that the coordination amongst creditors, in case there are multiple creditors, is very important. So then the I think this is all as far as uh, this structuring is concerned. This total framework is concerned. So I think, Ankit, we can take in case there are some questions, but this is all what we said, that High Court judgment is again these overturned by Supreme Court. A specific focus on MSME. MSME are protected. Banks have to go through that MSME revival and restructuring framework. So this is all, and the MSME revival and restructuring framework also is something which can be used by MSME enterprises. Let us see if there are questions.
So one of the questions kind of is an opinion that mandatory restructuring would not be possible. That's the opinion that is coming in. So
Mandatory restructuring is not possible.
so mandatory restructuring is not even perhaps mandated. We're looking at like the idea is that the bank should seriously consider the restructuring plan if something comes to them. That's the idea. Of course, the bank has the rights to say that this restructuring plan is not feasible. It is something which cannot be taken further. But what we have seen normally, what happens with banks is that the restructuring proposal, when submitted with the bank, does not see any revert in many banks. There is no answer from the banks for months and months that okay, what was our decision on the restructuring plan. So that's, I think, something that can be changed based on this judgment now. That will need to be answered, or that will need to be rejected, or that will need to be kind of that will need to be considered. Then Ritesh is saying that if any MSME account has already been classified as NPA, but SARFAESI action are not started or concluded without adopting the revival framework, do the bank need to reclassify the account as per SMA categories, or the banks can proceed with SARFAESI action? So
No, in
NPA,
case, I think, Ankit, in case the banks have not passed through the entire route of classifying the account as an SMA 0 first, SMA 1, and then SMA 2, and straightforward classified as NPA, then again the bank will be impacted adversely with this judgment. The borrower may challenge that this process has not been done by the bank.
so there the bank will have to simply write to the borrower and say that, okay, although we did not classify this as an NPA after the due process of SMS 0, 1, and 2, or rather we did not communicate SMS 0, 1, and 2, but we now give you, these 3 months of time for you to take corrective action, which was otherwise available to you in case we would have provided that option to you at that point in time. That is the only solution today because the account is NPA today.
The banks can actually send a communication that in case you want to submit any cap, any like corrective action plan to restructure your account, kindly submit that resolution plan. We will consider. The bank can again consider it in 30 days and send it back,
Yes.
maybe
Then
accept
send
or reject it.
Yeah, then send reminders to that borrower so that that documentation with respect to follow up on the corrective action plan can be produced in case the borrower litigates on this front.
Right.
So I think with that, all the questions are taken care of. I don't have anything else with me. And I
I think
believe
some Ratish is there in case he wants to say something.
I will just allow it. Yes, Satish, maybe you can unmute yourself and say what you have to say. Ratish,
Am I audible?
you're audible now.
Yeah. See, the process of classifying the account as SMS 012 is not a manual thing, and it necessarily passes through this. There is no separate process. It is a system-driven process, and in all banks, it is from 1 to 30. It automatically gets classified as system-driven. It gets classified as SMS 012, and that time onwards, the follow-up with the customer for initiating, recovery. No, not recovery, rectification, and then regularizing the account. The process will be there. The monitoring department will be behind them, and this will be there. We cannot simply say that bank has not classified it as SMS 012. It is a normal process which happens through the system. 012, it will pass, then only it will reach NPA level. And during this process, many of the MSMEs, what we have observed from our experiences, activity would have stopped. There is no activity, there is no cash flow, the promoter is not cooperating. All these things, it becomes difficult. They don't have sales, or there may be some external or internal reasons why the account is showing stress. Unless they have a clear-cut mandate or plan with participation in the sacrifice that the bank is doing, they also need to bring in funds or something to that extent. If there is no clear-cut understanding on that, no corrective action plan can be initiated, and it will not work just like that. So the court coming inside and telling that this is mandatory, yes, it is mandatory, but then again, it doesn't move like that. I can't understand, what is the rationale behind this, because the banks would have already tried all these things, and then since nothing is working, they would have come forward. Just like that, somebody is not held-bound in enforcing SARFAESI Act.
So Ratishji, I think there needs to be a differentiation, which is of course practically required to be done. That in case a bank is, of course, we understand that this is automatic classification in most or maybe I can even say all banks. But what I think the court says is that the borrower should actually be informed about
It is always informed. See, it is not a monologue or anything of that sort. Just like that, mandatorily doesn't happen. Bank is also equally concerned. When the account is showing stress, there will be n number of emails, letters going from the bank, and then calling them to the branch.
I understand.
All those things are there.
But here in these cases, which went all the way to the High Court and the Supreme Court, perhaps that documentation was
no. I think it has only litigation value, nothing more than that.
Yes, I think it is like as I said, this scheme is as old as 2015. Most of the banks have the committees in place, and these borrowers have gone to High Court and then Supreme Court, and then finally they could convince the Supreme Court that the banks have not gone through this process of SMA 012, and they have not classified the account as NPA by following this MSME revival and restructuring framework. That they could actually somehow they could establish it before the Supreme Court. However, this particular judgment of Honorable Supreme Court is in fact refocusing on this framework, and probably the banks will be slightly more cautious. That's the only outcome now. And also the MSME units may even use it more for litigation. That also is one possibility. So thank you very much, Rafi. And I think we can conclude the webinar today. Thank you. And it is our way of learning. Thank you.
Thank you, everyone.